What is MCL 257.303? And how does it affect out-of-state licenses? If you move to Michigan and discover that an old out-of-state licensing action is blocking you from getting a driver's license, you are not alone. MCL 257.3031 prevents the Michigan Secretary of State from issuing a license to anyone whose driving privileges are suspended, revoked, denied, or canceled in another state. That out-of-state problem follows you across state lines and must be resolved before Michigan will issue you any license at all. When another state takes action against your driving privileges, that record is shared through nationwide reporting databases like the National Driver Register's Problem Driver Pointer System. Michigan reviews these systems before issuing or renewing any driver's license, which means an old action from years ago can surface the moment you walk into a Secretary of State office. Many drivers in Oakland County only discover the hold when they try to transfer or renew a license, and the Secretary of State declines the application on the spot. The statute does include a limited exception worth understanding. If the action was imposed by a jurisdiction other than the one that last issued your license, the Secretary of State may issue a Michigan license after 5 years from the effective date of the most recent action. However, because the statute says may rather than shall, reaching that 5-year mark does not automatically guarantee you a license. Out-of-state convictions can also trigger the habitual offender presumption under MCL 257.3034b, making a Michigan license significantly harder to obtain because the conviction record alone can establish the designation unless you successfully rebut it. The conviction combinations that support this presumption include 2 reckless driving convictions within 7 years, 2 qualifying alcohol or drug-related driving convictions within 7 years, or 3 such convictions within 10 years. One important protection under MCL 257.303(6) is that multiple convictions arising from the same incident must be treated as a single violation, which can sometimes change whether the habitual offender presumption applies to your record at all. A careful review of the out-of-state paperwork by an experienced attorney can reveal that what appears to be 2 separate offenses is legally counted as one, opening a path toward restoration. Michigan defense law attorney Paul J. Tafelski has practiced law in Michigan for more than 20 years and represents drivers throughout Oakland County who are navigating license holds and restoration matters involving out-of-state records. As a seasoned lawyer who has been selected to Michigan Super Lawyers from 2011 through 2026, Paul Tafelski focuses on reviewing each client's full driving record, identifying errors and openings under MCL 257.303, and preparing the documentation needed to clear the hold. Whether you need to resolve an out-of-state hold to obtain a Michigan license, or a Michigan revocation is preventing you from getting licensed in the state where you now live, this law firm is prepared to help you understand every available option. The law firm offers representation through administrative hearings and circuit court appeals, giving drivers multiple avenues to challenge a hold and get back on the road. Call Michigan Defense Law at 248-451-2200, located at 2525 S Telegraph Rd Suite 100, Bloomfield Hills, Michigan 48302, to schedule your consultation with a lawyer who can review your driving record and explain exactly how to move forward.